Come back with me now to the early 1970s. Technological advances have led to a new surveillance technology: miniature radios. So now the government has a new tool. Federal agents can use a concealed radio transmitter worn by an informant to broadcast and record a private conversation with a co-conspirator. In this instance, someone who will later become named as a criminal defendant. The criminal case is real. It's called United States versus White. The defendant was James White. The government informant was Harvey Jackson. Jackson had concealed a radio transmitter on his body, and law enforcement authorities monitored the radio frequency the transmitter was tuned to. Imagine White's surprise when he learned later that Jackson had been, as we say now, wearing a wire. On 8 different occasions, the hidden radio transmitted Jackson's conversations with White to law enforcement authorities, including on one occasion at White's home. Based in large part on these conversations, White was criminally charged with drug trafficking. By the time of trial, however, the informant, Jackson, had disappeared. The trial court let the government proceed by having the agents who'd listened in on the conversation testify as to what they overheard. On this basis, it was no surprise that the jury convicted White. But the accused drug trafficker then challenged his conviction. His main argument on appeal was that this new form of surveillance violated the Fourth Amendment to the U.S. Constitution. That amendment, part of the original Bill of Rights, reads as follows: "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." White argued that he had an expectation of privacy in his conversation with Jackson, and that the government's surreptitious electronic interception of that communication violated his rights. So, what should the court have said to White? Was he right or wrong? On its face, White's argument has a bit of a problem. His statement that he had an expectation of privacy and that it was violated runs square into the fact that the word privacy isn't in the amendment. What the amendment prohibits are searches and seizures. And not all searches, only unreasonable ones. White's argument wasn't frivolous, though. You see, for years, the Supreme Court had said that the only way to measure reasonableness was by reference to law and legal restrictions. It was, for example, unreasonable to enter a house without a warrant, because the law protected homes against external invasion through laws against things like criminal trespass and breaking and entering. By contrast, if no laws prohibited someone from walking in an open field, then police walking about the field were not being unreasonable, even if they were conducting a search. That all changed in 1967 in a case called Katz versus United States. Charles Katz was a bookie who used a public payphone to conduct his business. The FBI, during its investigation, recorded Katz by attaching an eavesdropping device to the outside of the booth. And this was all back when people actually used payphone booths. Under the old-style law, because there was no physical intrusion into the phone booth, there would have been no legal barrier to what the FBI did, and hence no unreasonableness to the search. But the Supreme Court nonetheless concluded that the FBI had violated the Fourth Amendment. In reaching that conclusion, the court modified, at least to some degree, how it defined what the Fourth Amendment protects. Justice John Marshall Harlan II's concurrence in the Katz case has come down to us as the best expression of that change. He said the violation occurred because, quote, "an enclosed telephone booth is an area where, like a home, And unlike a field, a person has a constitutionally protected, reasonable expectation of privacy, that electronic as well as physical intrusion into a place that is in this sense private may constitute a violation of the Fourth Amendment. From this, Justice Harlan derived a two-part test for when one has an expectation of privacy. It existed if, 1, the individual has exhibited an actual subjective expectation of privacy, and 2, society is prepared to recognize that this expectation is objectively reasonable. The court in Katz was not unanimous. In dissent, Justice Hugo Black said the Fourth Amendment was meant to only protect things from physical search and seizure, and that it had no relevance to personal privacy. As we'll see shortly, Black's losing argument in the Katz case took on new importance when technology began to render irrelevant the walls of a phone booth. Still, in the Katz opinion, you can see the nature of White's argument a few years later. In the apparent sanctity of his own home, the suspected drug dealer was surreptitiously recorded with the help of a miniature transmitter. By engaging in this conversation in a private space, White's attorneys argued, he was manifesting a subjective expectation that the communication with Jackson was also private. If he'd wanted to have a non-private conversation, White's attorneys argued, he'd have done it outside, on the street, or in a movie theater, say. Likewise, White said it was reasonable to conclude that personal conversations inside one's home, or the home of a friend, were intended to be private. You and I would almost surely agree that the conversations we have with friends and family in the privacy of our own homes are not generally intended for public consumption. But White lost anyway. The court said White had no right to assume that Jackson would keep their conversation confidential. He could talk with the police if he wanted to, Jackson, just as my friends in high school were under no legal obligation to keep secret my crush on Lori Lample. In other words, White's expectation of privacy did not rise to a reasonable expectation that his co-conspirators would not rat him out to the police. Departing from the privacy question, the court opinion also relied on the fact that an electronic recording was actually better in the sense of more accurate evidence than the testimony of an informant. Quote, an electronic recording will many times produce a more reliable rendition of what a defendant has said than will the unaided memory of a police agent. It may also be that with the recording in existence, it is less likely that the informant will change his mind, less chance that threat or injury will suppress unfavorable evidence, and less chance, the court said, that cross-examination will confound the testimony. Justice William O. Douglas dissented quite vigorously. Here is how he characterized the problem. What the ancients knew as eavesdropping, we now call electronic surveillance. But to equate the two is to treat man's first gunpowder at the same level as the nuclear bomb. Electronic surveillance is the greatest leveler of human privacy ever known. How most forms of it can be held reasonable within the meaning of the Fourth Amendment is a mystery. But let's not forget Justice Hugo Black's dissent in the earlier Katz phone booth case. Black's minority opinion then was the converse of Douglas's losing argument now. Eavesdropping had been common at the time of the Fourth Amendment. But back then, when it was drafted, nobody thought the Fourth Amendment prohibited eavesdropping. According to Black, if the drafters had wanted to prohibit eavesdropping, they would have addressed it directly in the Fourth Amendment. And since they didn't, by definition, one couldn't cite a reasonable expectation of privacy as a protection against eavesdropping, or, by extension, against wiretapping. There you have it. Two justices, Douglas and Black, both known to history as giants in the protection of civil liberties, reaching diametrically opposed conclusions with one common analogy. It's enough to make your head spin. This story, the evolution in law that led to White's drug-related conviction, goes a long way to explaining why, at least for now, constitutional law has little role in regulating the collection of internet and telephone data about an individual. My expectation of privacy ends at your doorstep. When I give you information, I lose control over how it is disposed of. This principle, soon to be called the third-party doctrine, was extended to the idea of personal data in two cases in the 1970s, United States versus Miller and Smith versus Maryland. In each of these, the question was, in effect, does an individual have any constitutional protection against the wholesale disclosure of personal information that has lawfully been collected by third parties? And in particular, could an individual use his or her Fourth Amendment rights to prevent the government from using data it received without a warrant from a third-party data collector? In both cases, the court answered with a resounding no. Relying on the reasoning in cases like White, the court said that one has no constitutional rights to protect information voluntarily disclosed to others. The Miller case, for example, involved bank records. The High Court found that the Fourth Amendment does not protect financial information that has been voluntarily disclosed by an individual to a bank against the subsequent disclosure of that information to the government. So, if you write a check to, say, a doctor or a political campaign, and the government wants a copy of the check from your bank, there is nothing in the Constitution that limits how they get it. They can just go to the bank and ask for it. Now, that decision surprises you, and it surprised Congress. So much so that lawmakers immediately passed the Right to Financial Privacy Act, which put limits back on what law enforcement could do. The Smith versus Maryland case was pretty much the same song, sung in a different key. In that case, the court held that records of the phone numbers called by an individual are not protected against disclosure to the government. If you're willing to dial the number or punch it in on your smartphone, you can't complain if your carrier hands it over to the law enforcement authorities. One of the real oddities of these two cases is that they're quite old. Both arose before personal computers even existed, and before there was much concern with wholesale collection of personal information. But that hasn't stopped courts from applying the third-party doctrine in the modern context. One result is that protections now vary between the content of a message, its text or substance, and the non-content portions, like the address on the outside of an envelope or the metadata of a phone call. In general, the Fourth Amendment does not protect the non-content portions of intercepted traffic, precisely because there's a reduced expectation of privacy in this information. If you tell your service provider who you're calling or where to send your email, you don't have a constitutional basis for challenging the transfer of that data to the government. By contrast, you don't tell them the content of your call or your private email, so that's something you still expect to be private. Now, at least one federal judge has found that Smith is too old and that it doesn't really apply to the digital age. But the reality is that courts are frequently unwilling and perhaps even unable to adapt in real time to new questions that technology raises. This expresses some of the limits that are part of our hierarchical means of analysis. The court moves slowly because it doesn't want to get the answer wrong. Supreme Court Justice Samuel Alito Jr. a conservative who has nonetheless been described as difficult to peg between being a literal-minded constructionist and a bit of a more adaptable pragmatist, captured the problem in informal remarks he gave to the Federalist Society, a group of conservatives and libertarians who are interested in the law. Here's what he said. The problem is, we are put in a position of determining what is a reasonable expectation of privacy. And as he explained, we, that is the Supreme Court, are very ill-positioned to make these determinations. We are older than the average person. This may come up as a surprise. We're not up on all the latest technology. If privacy is to be protected in the future, that balances the interests of law enforcement and the interests of privacy, legislatures should take the lead. They are in a better position than the courts. However, pressure is growing, and soon the courts may be obliged to act. So let's turn now to another aspect of the constitutional law system, one that also bears on the idea of privacy and which also seems counterintuitive. It's the issue of consent. Now, consent solves most of our constitutional problems with government search and seizure. If you give your consent to a police search, then, almost by definition, the search is reasonable. Provided that you're not coerced into giving your consent, a citizen's decision to permit the government to scrutinize his actions is an authorization. In an ideal world, consent would be the bedrock of such authorizations. After all, our broad theory of governance in the United States is founded on the consent of the governed. Consent to a search is simply that same concept writ small in the context of an individual's confrontation with the state. So at bottom, the idea of consent is a core of democracy, and in many ways, it's a barrier to unreasonable government surveillance. The corollary is that in the absence of consent, surveillance would not generally be permissible without a warrant. But here, our theory runs into the relatively narrow definition given to consent by current court interpretations. The case of John Gilmore gives us a good sense of the issue. Gilmore was a civil liberties activist who sued the United States. He wanted to be able to fly on airlines without showing an identification document, such as his driver's license. Now, prior to the 9/11 terror attacks, this was something you were allowed to do. I can recall boarding the Eastern shuttle from Washington, D.C. to New York without a ticket and just taking an open seat. Once on board, I could pay for the trip with cash or a credit card during the flight. The flight attendants rolled a cart down the center of the aisle and took payment while we were in the air. No ID was necessary if you paid cash. Of course, all that changed after 9/11. One of the new forms of government surveillance that came about as a result was enhanced airport screening. Some of that was physical screening, with which we've all become quite familiar. But another aspect was identification checks and cross-checks of your name against lists of known or suspected terrorists. For that to work, you had to provide a picture ID. And that identification requirement is what Gilmore challenged. He argued that the Supreme Court had recognized Americans' constitutional right to travel. And Gilmore said that right could not be conditioned on subjecting oneself to a violation of a reasonable expectation of privacy under the Fourth Amendment. In other words, he argued that combining the Fourth Amendment protection with his right to freedom of movement meant that he was entitled to travel without showing a picture ID. Gilmore lost his challenge in a case that goes by the title Gilmore versus Gonzalez. The Ninth Circuit Court of Appeals decided the matter on two grounds, one relating to reasonableness and another relating to consent. The first part of the decision is broadly relevant to our discussion of surveillance. It concluded that requiring identification is fundamentally reasonable. In other words, the court said that it would balance the modest nature of the intrusion into Mr. Gilmore's privacy, merely requiring that he show an identification document, against the significant government interest in preventing aviation terrorism. And when it did so, the balance favored the government. That aspect of the holding suggests a little bit about why government surveillance programs so often are upheld by courts. Important, weighty national security interests routinely trump individual privacy concerns. The other aspect of the case turned on this notion of consent. The court said that by buying a ticket when he knew that he would be subject to airport scrutiny, Gilmore had implicitly consented to that scrutiny. The choice to fly on an airplane was Gilmore's to make, and it was not compelled in any way by the government. He had, they said, other modes of travel open to him. He could, for example, take the train or a bus or drive his own car. And so, the court found, he could not complain about the conditions that the government applied to his choice. Well, Gilmore had options, in theory, but in practice, maybe not. How, other than flying, might one get from Los Angeles to London? By boat, I suppose. You can see why this idea of consent is relevant to our discussion of the search of metadata. How realistic is it that you won't use a smartphone and create metadata about your phone calls? The logic of the consent rule in Gilmore captures a great deal of everyday life in America today that we would not think necessarily of as voluntary. But there it is. Voluntary in theory, pretty much mandatory in practice. The same is true in lots of other contexts. Another example. If a police officer pulls you over and says, "I'm going to take you down to the station for questioning, but I won't if you consent to letting me search your car," and you agree, we say that's consent too. So the current state of constitutional law is one where the doctrines of law really don't protect privacy, at least not with respect to metadata and other forms of digital information. All of this might change, though, because of growing public and governmental concerns over problems of big data. In February 2012, the Supreme Court decided a GPS tracking-related case called United States v. Jones, in which 4 of the 9 justices, not a majority, said that the collection of large volumes of data raises constitutional issues because it allows the collection of enough data to create a mosaic picture of a person. With one more vote, the mosaic concern would constitute a majority. And out of that, the court could require government authorities to obtain a warrant, at least to collect bulk quantities of digital data. If the court were to go down that path, it would certainly change some aspects of our constitutional law. It would distinguish between the bulk collection of data, like the metadata in the massive databases of calling records, and small-scale collections on individual cases. Collecting all metadata might even be prohibited. But when the government sought the metadata of a specific individual, it might be allowed. One justice in the Jones case, Justice Sonia Sotomayor, would have gone even further than her colleagues. Justice Sotomayor said she was willing to completely revisit the third-party doctrine, the one that goes back to the Smith and Miller cases. Now, I suspect that it is unlikely the court will take that path, since it would mean unraveling a host of other related doctrines that are at the heart of U.S. criminal investigative practices, like the informant doctrine in the White case with which we started this lecture. But it is quite possible that the justices will come to recognize that big data collections are different in kind, not just in degree, from collections of small amounts of data. The issue is summarized best in a statement from a federal appeals court judge, David Sentel, who considered the Jones case in the lower court before it went up to the Supreme Court. Judge Sentel was against Jones in the case. His argument was that if all individual collections of data leading to the bigger picture were authorized, then the bigger picture itself was as well. As he put it, if the reasonable expectation of privacy in a single piece of data is zero, then the sum of an infinite number of zero-value parts is also zero. Another way in which change might come lies in the technological necessity of modern digital systems. This concept was considered in a recent case called Riley versus California, which involved smartphone privacy. To understand Riley, you have to have a little background about a constitutional doctrine known as search incident to arrest. The idea, which goes way back in English history to before America was even a country, is that when there is probable cause to believe that someone has committed a crime, and when that person is arrested, that determination carries with it an authorization to search them. Sometimes, this doctrine is justified on the grounds that once there's probable cause to arrest, then there's also probable cause to search, since the suspect might be carrying evidence of the crime of which they're suspected. Sometimes, the doctrine is justified based upon preserving a police officer's safety, if a search is necessary, say, to make sure that the suspect isn't concealing a weapon. Other times, the doctrine is based on the argument that you don't want an arrestee to destroy evidence, so the police have a reasonable grounds to seize everything. So, based upon this historical practice and these strands of analysis, the search incident to arrest is commonplace today. The police conduct a thorough search of anybody they arrest and are free to read or look at everything that's in the person's pockets. For example, if you're arrested, the police can read the notes you have on little bits of paper in your pocket. But the foundations of this doctrine are a bit shaky to some. The police can read the phone numbers in your pocket or the text of your diary, even if those writings are no threat to the officer. And even though once they're removed from your pockets, there's no risk that they would be destroyed. Indeed, the search is permitted, even if there's no reason for the officer to think that the notes have any relationship to the crime for which you're arrested. If you're arrested for drunk and disorderly conduct in public, the police can still read your diary in your pocket, even though it had no reasonable connection to any crime of which you're suspected. That's the law today for physical searches, even if it might not seem to make that much sense. Riley involved the question of how this doctrine of search incident to arrest would apply to smartphones, like an iPhone. The logic of the government's argument was quite simple. It argued that the phone was just like a diary or a notepaper, and that the police were entitled to search through the phone simply because it was in Riley's pocket at the time of the arrest. Truth be told, the government had a very strong case under the doctrine as it existed before Riley. And I personally thought they were going to win. If the police could read my diary, then they could read my diary on my cell phone or any other data that I might have saved to my phone. I was wrong. The court decided that the data on Riley's cell phone was protected by the Fourth Amendment. And it did so because it recognized that, in some way, smartphones are different than diaries, and thus that the rule of search incident to arrest simply should not apply. As Chief Justice John Roberts wrote for the unanimous court, modern cell phones are not just another technological convenience. With all they contain and all that they may reveal, they hold for many Americans the privacies of life. The fact that technology now allows an individual to carry such information in his hand does not make the information any less worthy of the protection for which the founders fought. Or, as Justice Alito put it in a concurrence, we should not mechanically apply the rule used in the pre-digital era to the search of a cell phone. Many cell phones now in use are capable of storing and accessing a quantity of information, some highly personal, that no person would ever have had on his person in hard copy form. And so, even though constitutional law does move slowly, sometimes too slowly, it does move. Inevitably, the law will catch up with technological reality. After all, it has to.